attending. My name is Sophie Parker. Today's webinar is on the Personal Property Securities Act 2009 and will be presented by Lavan Legal Associate Dan Butler. Before we meet the speaker, I would like to give you a brief overview of today's webinar. If you have any difficulties viewing the presentation, please call 0419 946 570. After the webinar, we will send an email to all attendees with a link to the recording and a copy of the presentation. We invite you to ask questions at any time during the presentation. Please use the chat box on your screen to enter your questions. We will respond to as many questions as possible. We do request that if you're listening via your phone or mobile, that you please submit all questions via the chat box. If you are a legal practitioner and would like to receive CPD points for this webinar, it is important that you remain in attendance for the full duration of the webinar. I'd now like to introduce you to our speaker. Dan Butler is an associate in Lavan Legal's Recovery, Insolvency and Reconstruction team within the Commercial Advice and Litigation Group. Dan has extensive experience in insolvency and bankruptcy, intellectual property and general commercial advice and litigation. He has completed the Insolvency Practitioners Association Advanced Insolvency Law and Practice course and has been admitted as a full member of the IPAA. He's worked on a large number of insolvency and administration matters with clients such as Westpac Banking Corporation, Mentor, National Australia Bank Limited and McGrath Nicol. Dan regularly appears as counsel in hearings in the Supreme, Federal, District and Magistrates Courts. Thank you for joining us today, Dan. I'll now hand over to you.
Thanks very much, Sophie, and thank all of you for joining us today for this webinar. We're going to be discussing a topic that I feel particularly passionate about. And what we thought was, with the PPSA now just over 1 year old, and with a number of cases having been determined, we thought it would be a useful time to really reconsider some of the key issues. And today I've decided to focus on two of those issues, being purchase money security interests and the vesting rules. Now, the way I propose to break it down today is to revisit some of the principles associated with those issues and then look at some actual cases that have arisen in the first 12 months and also deal with some case studies that have been invented for the purpose of presentation. So I guess at the outset I just want to identify the objectives that I'd like to achieve today. There's probably four main objectives. The first of those is to help you avoid some common mistakes in dealing with PIMDs. Also to clarify the new rules around vesting and voidability under the Act and also under the Corporations Act. To clarify the limited circumstances in which you might obtain some leeway from the courts under the PPSA in respect of vesting, which is what I've identified as the Oliver Twist provision, or the "please sir, can I have some more time," which is the section 588 FM and the cases that have gone with that. And also to remind you that we're here to help on all things PPSA related in your practice from day to day. And in that spirit, whilst there may be some questions that I get to today, some I may not. So I'd be more than happy for you to make contact in the coming days to raise any other issues you have, and I will endeavour to respond to any queries that are raised today or in the coming days in a timely fashion. So let's start by looking at PIMDs. Purchase money security interest is a security interest that facilitates the acquisition of personal property. It could, for example, be granted in favour of a lender who advances a deposit on the purchase price, or in favour of a supplier who supplies goods on reservation of title terms. I just want to note at the outset that ROT arrangements didn't become invalid after the 30th of January 2012, last year, but we think their utility will diminish throughout the 24-month period from that date, in respect of which we only have about another 9 months left. So where goods were supplied under a pre-30 January contract, The ROT, in respect of that supply, may, subject to some qualifications, have priority over other security interests for a 24-month transitional period. But they must be registered as a PIMSI before the end of that period, or they will thereafter lose their priority as against other registered securities over the same property. So let's look at the key features of PIMSIs. PIMSIs have a number of key features, including a one-time registration facility by a secured party, which can cover multiple transactions with the same buyer or lessor. It can, subject to certain exceptions, which we'll get to, have priority over, or afford a priority under the Act over most other securities, which we call the super priority. And there are specific provisions under the Act, some of which we'll get into today, that deal with those, deal with the super priority. It can survive a bankruptcy or liquidation of the grantor party, subject to the PPS register's general searchability issues, including, I note, the fact that the register is going to be offline over some part of this weekend. That registration is searchable on the PPSR. Usually allows tracing into the proceeds of sale of secured property, and can survive the commingling of the secured property or its processing into another product. So those are just some of the key features associated with PIMSIs. Now, I'm not going to go back over all of the general rules around priorities, which we discussed in last year's PPS webinar. Safe to say that in the context of an enforceable PIMSI, that security interest will have the benefit of defeating most other non-PIMSI security interests, even if those interests were created or registered beforehand. And this is the super priority. And there are exceptions, and I want to identify several of those now. These include factor purchasing, perfection by control by another party, another secured party, perfection by possession by another secured party. Now, the other exception, in inverted commas, I've identified here is human error. Obviously, this is an exception in practical terms rather than one that's built into the legislation itself. And what I mean by that human error is the failure to correctly register a PIMSI or register it in a timely fashion. This would seem perhaps even more so than the other exceptions that I've referred to above to have been a most serious issue over the past 12 months, and more serious than the loss of the super priority through any of the other exceptions I've outlined above. And I'd be interested in anyone's comments about that down the track via email or over the phone, or however you'd like to communicate that to me. But that's been our assessment. Why is this the case? Well, really it's because the design of the PPSA is such that it requires adherence to some fairly onerous deadlines and drafting requirements, which we need to be aware of. So in that vein, let's briefly reconsider some of the key rules and points to remember in relation to PIMSIs. First of all, a PIMSI in respect of inventory that is goods must be perfected before the grantor obtains possession of those goods. This is section 62.2. A PIMSI in respect of inventory that is not goods must be perfected before the PIMSI attaches to the inventory. A PIMSI in respect of goods other than inventory must be perfected by registration before the end of 15 business days after the grantor obtains possession of the goods. A PIMSI in respect of personal property other than inventory that is not goods must be perfected by registration before the end of 15 business days after the security interest attaches to the property. Now, just going back through those, it's clear by any assessment that those definitional requirements can lead to a little bit of confusion and uncertainty about what needs to be done when, and this is one of the things that I identify in the subset of things that constitute human error, perfectly understandable in many cases. Now, importantly, and this is one thing that we've seen on several occasions, a PIMSI holder needs to correctly register that PIMSI if they are going to obtain the super priority. Now, there's the table in section 153 of the Act. The tables are very helpful within this legislation and also need to be fully complied with. And you know, the mere act of failing to tick the right box may have serious ramifications for security holders in terms of their obtaining and retaining their super priority. So it's really important to bear all of these things in mind when assessing PIMSIs. A failure to register a PIMSI within the relevant time frame isn't necessarily going to invalidate the security interest, but it can deprive the PIMSI holder of the super priority, which can have serious consequences in practical terms. So now let's look at some case studies. And I'll point out that most of the rest of the session today is based around case studies, either invented or actual live case studies. So you can see there on the overhead the general layout in this one. Mining Co is a company that provides mining services in the Midwest of Western Australia. Obviously not a real company. It's obtained working capital from Bank Limited, and apologies for the lack of creativity associated with some of these case studies, and in the form of a $2.5 million loan facility. Now, as security for this facility, Bank Limited took a fixed and floating charge over Mining Co's assets and undertakings in December 2011. It subsequently registered that interest on the PPSR on the 30th of January 2012. It didn't register that interest on the old ASIC register of charges. Now we look at Digger Finance. Mining Co's plant and equipment is financed by Digger Finance Proprietary Limited under commercial leases. Amongst that plant and equipment, it has 4 tilt tray trucks, which have been leased for 3 years, commencing on the 3rd of March 2012, and a crane which is leased for 9 months, commencing on the 10th of March 2012, with an option to extend for a further 9 months. The crane, which weighs 5 tonnes, is transported to the mine site by truck. It's not attached to the actual mine site. So Digger Finance, as you can see there in the diagram, registered its security interest in the tilt tray trucks by the correct serial numbers as PIMSIs, and in the crane as a PIMSI in other goods. And registration was effected on the 6th of March, 3 days after they were delivered to Mining Co. So I just want to flag these dates are all fairly significant. So 3 March is a significant, 3 days after delivery is a significant point to this case study. Now we move down to More Ore Proprietary Limited, an iron ore miner, and on the 4th of April 2012, it engaged Mining Co to conduct pre-strip and overburden removal work on More Ore's mine site, also in the Midwest. Again, More Ore made up company. Digger Finance made up, Bank Limited obviously also made up. So what happens next? Mining Co moves the tilt tray truck from the crane to the mine site and uses the equipment to provide its services to More Ore. The mining services contract with More Ore provides that More Ore is entitled to take possession of Mining Co's plant and equipment at the mine site and retain it until the services are completed. However, More Ore did not register any security interest on the PPSR. access to the mine site is controlled by More, and it doesn't allow anyone else to enter the site until an induction program is completed. So there are several questions here. First of all, what are the various security interests that we have in a PPSA world? And secondly, to the extent that somewhere in there's a PIMSI, which I think I identified there probably is, where does it rank in terms of priority? Well, as the diagram shows, Digger Finance has a PIMSI, and as I mentioned, it was registered on the 6th of March, 3 days after delivery of the equipment to Mining Cove. And what's the significance of this? Well, that means that it was registered within 15 business days after the plant and equipment was delivered. Therefore, it won't lose its super priority under Section 62 of the Act, based on delivering more than 15 days before registration. Its PIMSI has priority over the other security interests that exist in relation to this case study, which I'll get onto now. So what was Bank Limited's interest, albeit one that was defeated by the interest of Digger Finance? Its interest was a transitional security interest. It wasn't registered within the timeframe provided under Section 263 of the Corps Act, but it was perfected by registration on the PPSR on the 30th of January 2012. More, as we mentioned, didn't register its security interest on the PPSR, so it won't take priority over Bank Limited, albeit that it might otherwise have done so. Under the default priority rules, a perfected security interest has priority over an unperfected security interest, and that's by virtue of Section 55. There's one other question here which some might raise, which is that maybe Digger Finance has perfected its security interest in the excavators and the crane by possession. The answer to this is probably that its interest wouldn't have been perfected in such a way, and that's because it doesn't have exclusive possession of the excavators and the crane to the exclusion of Mining Cove, and that's why we raised the bit earlier on about Mining Cove being in control of access to the site. And because of Section 24, this will defeat any sort of argument around having perfected by possession, in my view. The excavators and the crane are, whichever way you look at it, in the actual or apparent possession of Mining Cove. So now we'll move to another invented case study. This is the second case study. It involves Steelmaker, a Japanese manufacturer and supplier, Aussie Infrastructure, and Iron Co Limited, again, all invented entities. So what's the arrangement that's in place here? Well, to start with, the grantor of the security interest in the steel and materials that's supplied by Steelmaker is Aussie Infrastructure. I think there may have been some confusion around which party in a PPSA sense is doing the granting, and it does appear perhaps counterintuitive that the party receiving goods would be the grantor, but nevertheless that is the case, and in this case Aussie Infrastructure has granted a security interest to Steelmaker Co, the Japanese manufacturer and supplier. Now once those supplies of steel and materials arrive in Australia, they will be governed by Australian law by virtue of Section 238 of the Act. And that's notwithstanding the fact that they were manufactured in Japan. Now, Steelmaker might have a PIMSI if the supply is on retention of title terms. Now, if that was the case, again, the PIMSI would have super priority over most other security interests if it was registered on the PPSR within 15 business days after they're delivered to Aussie infrastructure. And this is because the steel and material are goods and they're not inventory. Once the steel and materials are incorporated into any building works on site, they could become commingled, and the supplier, Steelmaker, would then have to look to the commingled goods provisions of the PPSR for a proportionate share of those goods or proceeds derived therefrom. I'm not going to go into that in any particular more detail today, but obviously happy to discuss further down the track. Now, if that structure in turn is affixed to land on the site, it would become a fixture according to the definition in section 10 and no longer be covered by the Act. The person then with a security interest or any mortgage perhaps over the land would be able to claim the structure as part of that land and subject to that security itself by virtue of section 73 of the Act. Now we're moving to a third case study, which again involves some invented entities. West Coast Shelf, Westside Energy, and Drilling Limited. And I note that JB should actually be JV, but I'm sure you all pick that up. Now, in this case, the secured party is Drilling Limited. It's supplying equipment to Westside in the form of a drilling rig. Now, one of the issues that's come up is around whether things become fixtures in the context of rigs, and our assessment is if something has been attached, if this drilling rig, for example, is attached to the seabed, it's likely to be a fixture and not covered by the PPSA. If it's a floating rig, it's probably watercraft and serial number goods and covered by this particular legislation. As you may be aware, serial number goods may be registered by serial numbers if they're commercial property, but it's in any event desirable to do that because otherwise a grantor may be able to pass clear title to any other purchaser, the grantor in this case being Westside. And that's by virtue of section 44. So just a few things to look out for there. The lease of the drilling rig by Drilling Limited to Westside is a PPS lease because it's a lease of serial number goods for 90 days or more. It is a PPS lease in this case because, although the diagram doesn't show this, Drilling Limited is regularly engaged in leasing drilling rigs, which is an important concept in the context of whether something is or isn't a PPS lease. In this case, it is something that is something they regularly do as part of their business activities. So as a PPS lease, the lease is also a PIMSI, and if drilling registers its PIMSI within 15 business days after delivery of the rig, it will obtain the benefit of a super priority. So we see here another example of super priorities. If drilling does not register within this period, it loses the super priority, but may still have a validly enforceable security interest. Okay, next case study on PIMSIs before we get on to the vesting and voidability matters. Bit of a simpler example here. You have LNG Cove, which is supplying extracted gas to customers. Now, if LNG, in this case, supplies extracted gas to a customer, as soon as it's delivered to, for example, Karratha at the end of the pipeline, this is a delivery of inventory to the customer and a security interest, for example, the supply on ROT terms, could be registered as a PIMSI. But this time we're dealing with inventory and not goods. So what we require is for the registration to occur before delivery of the inventory, as in before the gas is pumped down the pipeline, in order to obtain the super priority. So this is just to emphasise the difference between inventory and other goods, and the timing issue that really does need to be complied with in all circumstances. It's important to note in this case that we're dealing with a supplier of extracted gas. It only needs to register one financing statement to cover its supplies of gas to these customers, and the registration would relate to gas supplied under any given security agreement. It would be necessary and excessive if the supplier was required to register a new registration each time. So, moving on. I think one of the other key areas that has arisen and that has had cases that have gone with it over the last 12 to 15 months, and therefore requires a bit of closer consideration, is the issues around vesting and voidability. The PPSA has, among other changes, introduced a vesting rule and also altered the traditional concept of voidability under the Corporations Act. And again, this is an issue that has provided some concern from our assessment over the past 12 months or so. So let's look at each of these in turn before we see how they apply to both our previous case studies and also how they've applied in recent live examples. Unfortunately, as the 15 months since the PPSA was introduced has progressed, well, we've seen some actual live Australian examples that we can rely on, and no longer need to rely exclusively on the authorities from overseas, places such as New Zealand and Canada. So let's look first at section 267 of the PPSA, which is where the vesting rule is contained. In essence, it provides that unperfected security interests vest in the grantor if any of the following insolvency events occur. If a winding up order is made or a winding up resolution is passed for a corporate grantor of that interest, if the corporate grantor of that interest is placed in voluntary administration, if the corporate grantor executes a deed of company arrangement, or if an individual grantor becomes bankrupt. So those are four fairly common events in an insolvency or bankruptcy context, but we note one that is missing from that list is the appointment of a receiver or a mortgagee entering into possession or appointing an agent to do the same, because an unperfected security interest doesn't automatically vest in the grantor simply because either of those things happen. So just to emphasise, whilst winding up orders, voluntary administration, dockers, bankruptcy will trigger section 267's vesting rule, the appointment of a receiver or the appointment of agents for an MIP or the entering into possession of property by a mortgagee themselves doesn't trigger this section. Nor does the vesting rule affect the title of a purchaser who acquires the personal property for new value from the secured party, or, as the case might apply, its receiver or agent, with no actual or constructive knowledge of one of these insolvency events. We haven't had any cases around this, but I do want to look at a couple of the interesting aspects that arise. One of the things that we've been emphasising for the last 12 months or so, and one of the conceptual shifts, I suppose, in the pre-PPSA law to the current law, is that vesting isn't the same as something being void as against the liquidator, which is probably how most of us understood the rules around these sorts of things to work before the PPSA. So it's clear that Section 267 provides that the unperfected security interest vests in the grantor, and not that it is void as against the liquidator, administrator or trustee in bankruptcy. And this is principally because some of the unperfected PPSA security interests that vest in the grantor upon insolvency weren't like other unregistered charges that were void against a liquidator or administrator under Section 266 of the Corps Act, or now Section 588 FL. So we're dealing with many different types of security interests, including some that we've discussed already today, including leases and bailments by the true owner of goods if they're security interests within Section 12.1. We're not just talking about charges anymore. The vesting rule in Section 267 doesn't apply to deemed security interests either, interests in chattel paper or transfers of accounts, PPS leases, or commercial consignments. But it does apply to transfers of account or chattel paper in circumstances where they do secure payment or performance of an obligation. Now, I'm not going to go into that in any more detail, but suffice to say, the point I'm trying to make is that this is all supporting evidence as to why the conceptual shift has happened, and why we also need to stop considering this as being a regime that applies only to charges and start considering that we're talking about a wide range of other interests that may exist and may, depending on the circumstances, fall within Section 267. And I guess that going back to the last point I made about whether something does or doesn't in substance secure payment or performance of an obligation, it's probably fair enough that the vesting rule would apply in those circumstances because the security interests there are genuine security interests. So we need to look at whether something does in substance secure payment or performance of an obligation, as well as looking at whether the relevant insolvency event has occurred to assess whether Section 267 will apply. There is some upside for parties who suffer from Section 267's consequences, and that is that to compensate the holders of genuine security interests that vest in the grantor upon insolvency, they are given a right to damages or compensation from the grantor. In effect, this right to damages or compensation is a right to prove for the amount of the secured debt in the liquidation, administration or bankruptcy of the grantor. This right is conferred upon certain secured parties because it's not always clear whether they would be entitled to monetary compensation upon termination of their security interest. And interestingly, the right to compensation, as in the right of proof, is confined to lessors and bailors under a PPS lease and consignors under a commercial consignment, but doesn't extend to the transferee of an account or chattel paper. So what I want to do now is, just to get a bit more value out of those earlier case studies, I want to go back to a couple of those case studies and look at the consequences of Section 267 applying to some of those security interests. So if we go back to case study 3, what we said earlier on about case study 3 was that if Drilling Limited didn't register within the 15 business day period, it could lose the super priority but still have a security interest that was enforceable. But, and this is a big but, if it had failed to register altogether and then a company administrator had been appointed over Westside Energy's assets, say a couple of days after delivery of the rig, then what would be the consequence? Well, the consequence would be that that interest would vest under Section 267 of the PPSA, and it's too late to register after that appointment. So whilst in theory, and as a matter of law, as a starting point, the registration can occur after delivery in this example. It doesn't stop the effect of Section 267 if an intervening insolvency event occurs before you actually get around to registering the interest. Let's go back to case study 1, again in the context of Section 267. In this case study, we noted that Bank Limited has a transitional security interest, an interest that arose under an agreement that was entered into before the PPSA came online. And we noted also that it wasn't registered within the time frame of Section 263 of the Corps Act, but was perfected by registration on the PPSR on the 30th of January 2012. So let's say an administrator is appointed to Mining Cove. What's going to happen to its interest at that time? Well, I'm raising this because this is another issue that has arisen over the past 12 months. That interest would have been void if an administrator had been appointed as at 30 January 2012. And otherwise, by virtue of the operation of Section 1504 of the Corps Act, the old Section 266 regime would not have applied, and because the interest is now registered under the PPSA, it's safe. So it's not going to be affected by the appointment of an administrator subsequent to that date, if such an appointment occurred, nor by any of the other insolvency events that I referred to in the context of Section 267. So now I want to turn to look at what became of the old Section 266 of the Corps Act. It's still around, but under a different guise. And where we find it is 588 FL. So just to go back, prior to the commencement of the PPSA and subsequent changes to the Corporations Act, the following provisions applied to the registration of charges. A secured party had 45 days to lodge notice of a charge, failing which the charge could become void in certain circumstances. However, that secured party could also apply for an extension of time, also under certain circumstances. Both of these sections are now repealed, and Section 263 has been replaced by 588 FL. And we're getting onto the recent live case authority here, so this is where it becomes perhaps a little bit more interesting. What 588 FL requires is that a security interest granted over corporate property must be registered within 20 business days after that interest is granted, or not more than 6 months before the liquidation or administration of a grantor. And as you can see, 588 FL has imported the language of grantor from the PPSA, and there are many provisions, including 1504, 588 FL, 588 FM, and numerous others that have been either introduced or amended so that we have consistency around the language, consistency with the language of the PPS Act. So this rule is relevant if the applicable security agreement is entered into within 6 months before the company enters external administration, or within 20 business days before that 6-month date. Otherwise, all relevant security agreements must be registered prior to the commencement of the 6-month period. Let's use an example to illustrate the point. And again, this is a made-up case study. We're getting to the actual cases that have been dealt with in courts. So, looking at this timeline, on the 1st of February 2012, Greenbank Limited entered into a general security agreement with Robotics, providing for a security interest in all its present and after acquired property. On the 1st of April, Greenbank registered its security interest on the PPSR. Stepping back, on the 1st of March, Robotics granted another security interest in all its present and after acquired property to Burbank. On the 14th of March, Burbank registered its security interest on the PPSR. On 14 April 2012, Robotics went into liquidation. So what happens to the bank's respective interests? Well, Greenbank's security interest vests in Robotics as the grantor upon liquidation because it was not registered within 28 days of its creation or more than 6 months before the liquidation occurred. And I find an example like this quite useful to cut through the language of 588 FL. So hopefully diagrammatically like this, this will add some real value. What about Burbank's interest? Well, it doesn't vest in Robotics upon the liquidation of Robotics because it was registered within 28 days of its creation. It was registered 13 days after its creation. And it doesn't matter in those circumstances that the interest was only registered 1 month before the liquidation. So as a result, Burbank's security interest, albeit that it was second in time, takes priority. And this is the result of 588 FL. Importantly, it is not the result of any of the priority rules under the PPSA. So now this is where we get into the more recent live court decisions. What might we say could have been done to preserve the position if Burbank had registered late? As I've said, I noted that it's got a valid and enforceable security interest here. But let's say it registered on the 21st or the 22nd of March. What could have been done to preserve its position? And this is where we get into section 588 FM. Section 266 has been 266(4), of the Corps Act has been replaced by this provision. What section 588 FM provides is that a court may make an order in favour of a secured party if it is satisfied that the failure to register the collateral earlier was accidental due to inadvertence or some other sufficient cause, was not of a nature to prejudice the position of creditors or shareholders, or that it is just and equitable to grant relief on other grounds. And by our assessment and what the courts have said in the recent cases is that the court is interested in looking at the criteria that it would have applied under section 266(4) to reach a decision about all of this. And as I mentioned, I'm calling it the Oliver Twist provision because it's essentially a request to the court to allow you some additional time in this case to get done what you should have done earlier on. So let's look at Barclays. What did we have in Barclays? And for the full citation, it's Barclays Bank, in the matter of Barclays Bank PLC 2012, New South Wales Supreme Court 1095. In Barclays, we had a secured creditor which failed to register its interest under a GSA, which was entered into on the 24th of April 2012, mainly due to inadvertence on the part of its solicitors and the relevant transaction manager. It appears that even though the solicitors had provided advice on the necessity to register within 20 days to avoid the impact of section 588 FL, that just hadn't happened. On an unspecified date in July 2012, at least 5 weeks after the time for registration had passed, Barclays became aware that it had failed to comply with section 588 FL. It then registered its security interest on the 9th of August 2012. So, realising the error in its ways, Barclays applied to the court to obtain relief under section 588 FM in the form of allowing for a 9 August 2012 registration date. Now, the court did in fact exercise its discretion in Barclays' favour and it allowed it in those circumstances to avoid the full impact of 588 FL. And the key criteria that it looked at here and the key factors in favour of Barclays were the solvency of the grantor at the time and the absence of any indication of any risk of winding up or administration in respect of the grantor, the fact that neither the grantor nor any related entity opposed the application, the fact that the grantor had not granted any additional security interests in the same collateral in the period between the time for registration and the date of the application, and the relatively short delay, which was approximately 2 months, between the last day of the 20-day business period and the actual ultimate date of registration. And what the court said here was there are analogous cases, for example, Reinvestor Proprietors Limited, which was a case under the old Section 266. Those cases are going to be relevant and important in considering whether to apply 588 FM. And in particular, as was relevant in Reinvestor, the court was looking at the accrued or accruing rights of other creditors and ultimately made a decision in favour of the secured party. Subsequent to the Barclays case, we had the case earlier this year of Cardinia Nominees Proprietary Limited, again in the New South Wales Supreme Court, and I won't go into detail on this one because we're running out of time. Cardinia also applied under 588 FM for an extension of time. As distinct from Barclays though, there were two differences in the facts. Another security interest had been first registered, apparently over a motor vehicle, to a financier, which was registered before the end of the 20 business day period for Cardinia's security interest to be registered. And the evidence about the grantor's financial position was incomplete at best. But in any event, after accepting that inadvertence was also a factor in this case, and that the delay, 5 days, in bringing the application was not so lengthy to mitigate against the grant of the extension, the court had a look at the impact on the priority issues and made the point, quite importantly, that any order it was going to make shouldn't impact on the priorities as between Cardinia and the grantor, and said, out of caution, because the grantor hadn't had because the other secured party hadn't had the opportunity to be heard, and because Cardinia accepted that the application shouldn't affect the priority position as between all secured parties, there was a condition imposed on the extension, preserving the other financier's position. So a conditional extension was granted in terms which would have allowed any liquidator, administrator, deed administrator, or any other unsecured creditor to apply to discharge the extension within 6 months from the date of registration. So, as you can see, Cardinia had some factors in its favour in the sense that it was applying closer to the date at which its registration should have been registered. It had factors against it, which were the incomplete financial evidence and also the fact that there was another secured party. But in that case, the court was still prepared on conditions to grant the extension of time. So as you can see, and taking it back to the case study that we talked about earlier, Burbank could potentially avoid any vesting that might occur, but it would be difficult, and there are some real evidentiary difficulties with getting up on an application of this kind. So I guess going back over what we've discussed and trying to summarise some of what we've said over the last 45 minutes or so, we have to be clear to register PIMSs as PIMSs. That means identifying whether something is in fact a purchase money security interest, and then making sure that the registration is done correctly. And that is a place where parties can come unstuck. And obviously we can assist in any registration issues that you may have in relation to PIMSs. PIMSs are limited to amounts advanced or credit given to acquire collateral. So you can't just claim something as a PIMSy if it is unrelated to the amount advanced or used to acquire the collateral, nor if the amount in respect of which you have a PIMSy has in fact already been repaid or satisfied. PIMSs over goods that are inventory must be registered before a grantor obtains possession. PIMSs over goods other than inventory must be registered within 15 days after a grantor obtains possession, although I make the point, as I did in one of the case studies, that you're not going to be able to rely on this if one of the insolvency events under Section 267 occurs. And in this light, there are many ways for unperfected security interest to vest in a grantor on insolvency. These include if a winding up order is made, if a VA appointment is made, if a DOCA is entered into, or if an individual grantor becomes bankrupt, but not necessarily just by the appointment of a receiver or agent for MIP. Although registration of interests on the register is optional, secured parties must ensure that any genuine or deemed interest in their favour are perfected, usually by registration, to prevent them from vesting upon an insolvency event. And we need to make sure that we're doing so well before a grantor goes into liquidation or administration. Now, obviously, sometimes that's not going to be easy to predict, but I do note there Section 588 FL and the effect of failing to register within 20 business days after the grant or less than 6 months before liquidation or administration occurs. So the key point there is perfect as early as is possible. Now, there is a way through this, as I've just discussed, 588 FM. It's available. It's not going to be available in all circumstances, or indeed probably in most circumstances. It's certainly not a cure-all. But if a party does need to rely on 588 FM, if you're applying based on what the courts have told us so far, you need to have comprehensive evidence demonstrating the grantor's solvency, their profitability and their financial position. Without such evidence, it's going to be very difficult to get up on any such application. Training is the key in all of this. The importance of registering interests in the timely fashion, the manner in which the registration occurs, and the consequences of failing to do either of these things properly. And any agreements that are entered into should also specify who's responsible for registration of a security interest. And if possible, parties should avoid letting that obligation become somebody else's business. So just turning to a few questions in the short time we have left. And as I mentioned at the outset, I'm more than happy to discuss any of these issues with any of you after today's session, via email or over the phone. There's a question which sort of touches on something that came up earlier, which is, are PIMSs available to fixtures? Fixtures are one type of tangible property that are specifically excluded under Section 8 of the Act, and the term is defined to mean goods other than crops that are affixed to land. That's in Section 10. It doesn't matter why the goods are attached. If they're affixed, then they are excluded. And that's the general position. But we have also had a case recently about fixtures, and that was the Cancer Care Institute case, one of the very few cases that we've had so far, but fortunately we've had some guidance on this issue. In that case, again, the New South Wales Supreme Court had a look at whether or not two linear accelerators which were bolted onto base plates and in turn cemented into depressions in the floor were fixtures under the common law and therefore not part of the land. So this concerned the concept of fixtures under common law, and while the court said that they didn't need to examine whether they were in fact fixtures under the PPSA, but when they applied the common law test, they did in fact say that registration of lessor's interest in equipment on the PPSA register would be an additional factor in reaching a conclusion that equipment was not intended to be a fixture at common law, even though it was affixed to premises. So I suppose it follows from that in commercial lease situations, we should make sure that issue is resolved in the terms of the lease dealing with fit-outs. And intention is going to be a relevant consideration when there's a dispute about whether a fixture can actually be removed at the end of a lease, for example. Another question around PIMSs and their validity in relation to goods that have been paid for. The Section 14 says that security interest is only a PIMS to the extent that it secures unpaid amounts. Now, once goods have been paid for, they may well be caught by the residual security interest under an all monies ROT, but it doesn't any longer satisfy the criteria for a PIMS, and then you're not going to have the benefit of the super priority rules that apply. So hopefully that answers that question. And one final comment. This is not on the list of questions, but I appear not to have any further ones immediately before me. That in terms of statistics, just as a final note, some people ask, what's the story with registration? There appears to be so many. I mean, people are spending all day searching and finding pages and pages of documents. Well, that's because there's been, as at December, 7 million registrations in total, and about half of those in relation to motor vehicles, and about 1.5 million searches in the December quarter. And if our experience is anything to go by, I think we've probably conducted about 1 million or so of those. So there's plenty of activity, and I'm sure it will increase over the coming weeks and months and years. So that's all from me today. If anybody has any comments, questions, please feel free to shoot me an email, send something through LinkedIn, give me a call, and hope to speak to you soon.
Thank you, Dan. That brings us to the end of the webinar. We hope you enjoyed it. Thank you again for joining us, and we hope that you'll be able to join us again for our next webinar.